Hello, everyone. I am Maria, Senior Associate at Sorainen Estonian office. I am here together with Kirill, my colleague from Belarus. We continue with the Sorainen arbitration series, interviews with arbitration institutions that are of particular interests to users from the Baltics and Belarus. And today we warmly welcome Alexander Fessas, Secretary General of the International Court of Arbitration. Alexander, very glad to see you.
And you, Maria, Kirill, thank you so much to you and Sorainen for the kind invitation.
Hello, Alexander, from my side as well. Could we start with your background, in particular, how you came to the Secretary General of the ICC?
With pleasure. So I'm a Cypriot national. I trained and practiced in law as an attorney out of Athens, Greece for a number of years. I began my practice as a lawyer by working at a boutique firm, at a boutique disputes firm that also had an emphasis on international arbitration. So I was quite lucky at the time, I think, to dive into this fascinating world from the very beginning. For a number of years, I was also a sole practitioner focusing primarily in arbitration and other dispute resolution processes before relocating to Paris about 9 years ago. At which point I joined the Secretariat of the ICC Court. For a first period, I was engaged in managing cases primarily out of Central and Eastern Europe, which for the Secretariat, as you are well aware, includes the Baltics and CIS jurisdictions. And then I moved progressively through different positions. I was in charge of a team that was managing matters in North America before moving to senior management. I was the managing counsel of the court for a number of years, and for the past 3.5 years, I have the good fortune of leading the Secretariat as its Secretary General.
Well, Alexander, ICC and the arbitration community in general is very lucky to have you.
That's very kind. Thank you.
So to add some more heat to the interview with a somewhat provocative topic, let's go with institutional or ad hoc arbitration. Does ICC even provide for an ad hoc services?
Actually, we do. Obviously, our main line of services is focused on arbitrations conducted under the ICC rules of arbitration, and that represents about 99% of our work and our current caseload at any given time. But as with some other arbitral institutions, we also provide services in ad hoc proceedings and in other institutional proceedings. We have a distinct and separate set of rules for those cases where ICC acts as appointing authority and provides a number of services. I'm tempted to reply to your question as to which one to choose by referring to something that many years ago was mentioned by the late Stephen Bond, who was one of my predecessors at this position of Secretary General. And he was a very staunch opponent of ad hoc arbitration, criticizing very eloquently the disadvantages to which parties and arbitrators are exposed to, and the potential risks of the arbitral processes that might arise in the context of an ad hoc proceeding. The main, I think, challenge being, of course, that aside the arbitration agreement, and unless the parties have chosen an institutional or a procedural setting, they're basically left to their own devices. And ultimately, in the absence of an overseeing or supervisory body, such as the ICC Court, any difference or any deadlock can only be overcome by resort to state courts. And obviously, as arbitration expands and its use becomes proliferated more and more, that means an excess of time and costs being expended in situations that are utterly unnecessary. So my advice would be to our fellow lawyers and in law firms and in-house counsel, of course, when you're drafting arbitration agreements, make sure you make the right choice. And if you are not sure about what the right choice may be, reach out to a reputable arbitral institution and ask for some ask for some perspectives and general feedback in this regard.
Well, thank you for this explanation, Alexander. I think you pretty much laid out the main selling points that we lawyers use when clients ask whether to opt for institutional or ad hoc arbitration. What you just spoke of is exactly what we've been explaining to clients as well.
I'm glad we're aligned.
So what is your personal opinion? Why do you think that parties from the Baltic states should be interested in resolving disputes in ICC? And when would it be appropriate for them to maybe opt for the ICC as a dispute resolution forum rather than go with another institution?
Well, let me begin with the second part of your question, which I think hopefully will also cover the first. What we see, if one looks really at the caseload that we have focusing on parties from the Baltics and also more broadly cases involving the Baltics, you would see two trends, and they're complementary. On the one hand, you have cases that are very regional and may even be qualified in the grander scheme of things as nearly domestic. And most of those cases are not necessarily the very high-end dollar in terms of the dollar value of the claims on the very higher end of the scale. Yet, if one puts this in the context of the overall caseload of ICC, one will also see that there are actually a lot of cases of this size or this sort of like making that one encounters across many different jurisdictions in which ICC arbitration is being used. So there is no definitely a defining characteristic with regard to Baltic disputes that can be taken out of this. At the same time, you also have a number of disputes which are purely international, sometimes involving states or state-owned entities, either from region or beyond, and obviously an investor interest. And again, in a purely commercial context, I'm still speaking about commercial disputes, of course. And those cases usually have certain procedural or even substantive complexities, and usually the financial or economic dimension of the case is quite important. So in a way, I think what we see as an emerging trend conforms, with regard to the Baltics, conforms to the general trends that we see worldwide. One thing that I think is notable with regard to those disputes is that there seems to be a progressively advanced understanding of the benefits of resorting to ICC arbitration, and I'm happy, of course, if time allows, to explain what they are. And I think it is, in a way, indicative of an indication of the disputes market in the Baltic states to want to be included in the world of cross-border disputes on an equal par with their colleagues across different jurisdictions. So I think it is that level of trust and also confidence that we actually see emerge in these cases.
Thank you, Alexander. And going from market level to kind of a personal level, could you enlighten us a bit more on what institution takes into consideration when appointing arbitrators? Are there some sort of internal guidelines that help to keep the high standard towards arbitrators in ICC?
Thank you, Kirill. Of course, we have internal processes and practices that guide the members of the Secretariat and indeed the ICC Court when it needs to proceed with making appointments. And the process in its defining features is set out, of course, in the ICC rules. I should premise my reply by saying that in ICC arbitration, there is a very, very strong presumption in favor of party autonomy, which means that essentially that it is up to the parties to decide how to constitute tribunals, and of course to retain the discretion in fully constituting the tribunals themselves. It is only therefore a residual power that the ICC courts in appointing arbitrators, and indeed I don't think it's probably about 29 to 30% of the cases only where the ICC court does proceed with making an appointment. Now, when the ICC court needs to make an appointment, obviously it's a very important decision, both in terms of the reputation of the court, but importantly also, it will have far-reaching effects into the way that the proceedings will actually evolve and ultimately into the end product, the arbitral award. So it is a decision that comes with certain high stakes. So how do we go about it? We have two ways, basically, of doing it. And again, in a way, the methodology is complementary in both. On the one hand, the ICC Court is a body incorporated in a larger structure, which is the International Chamber of Commerce. And the International Chamber of Commerce has a wide network of national committees. If you like, broadly speaking, it's national chapters. And therefore, it has an immediate access to a network of arbitrators across different jurisdictions, from which it can draw upon relying on the expertise of national committees, request their proposals, and then vet those proposals in order to find the best suited and best available candidate. In some cases, where there is no national committee present or where a state entity is involved in the case, for instance, the ICC Court will also not use this process and go directly and appoint an arbitrator. In those cases, it will also more or less draw upon the Secretariat's experience and its own experience. We're very fortunate to be managing anything from 1,600 to 1,800 pending cases at any given time. And you have a lot of arbitrators and a lot of counsel active in these cases. And another benefit of the institutional system that is set out in the ICC rules is that the Secretariat has this supervisory function and therefore is able to witness the progress and performance of arbitrators and counsel in these cases, and therefore is able to have a rather wide pool of potential arbitrators from which to draw. Ultimately, of course, we're very rigorous in making sure that conflicts are vetted, that arbitrators understand their obligations with regard to efficiency, and also the timely submission of awards. So all of these issues are actually considered when an appointment is being made, aside any specific circumstances. So proficiency in a specific law or linguistic requirements or experience in specific sectors and so on and so forth.
Well, appointment of arbitrators is, of course, a very important part of any arbitration proceeding. But how does the ICC Court keep an ear to the ground with the arbitration proceedings after the file is transmitted to the tribunal? And does the institution provide any guidance to newcomer arbitrators?
Well, it's true that an institution usually has, seemingly at least, less work to do once the file is transmitted. It's more on the lawyer side, as you know, and the arbitrators to actually do all the dirty work. But our system of administration is in a way premised on a rather marked presence by the Secretariat throughout the proceedings. Which has both formal and perhaps less formal aspects to it. The formal aspect is that obviously you monitor the financial aspect. You are there to make sure that the procedural calendar is maintained or to track any changes in this regard. As I mentioned earlier, monitor any potential time impacts by adverse circumstances such as the COVID pandemic, and also ensure timely submission of arbitral awards and other decisions. There is an informal aspect of this practice or this activity, however, which cannot go unnoticed. And I think ultimately, given that parties pay the ICC Court an administrative fee at the end of the case, both parties and arbitrators should make good use of it. And that is also something you see coming into the guidance you just mentioned to newer practitioners and arbitrators with perhaps less experience. And what that means is that the Secretariat is only a phone call or an email away. We are not here to provide legal advice. We cannot provide legal advice under the rules, of course, and we must always observe strict neutrality. But what we can do in the context of these parameters, or in the limits of these parameters, is to provide support and clarity with regard to how the rules are being applied, and of course, with regard to the court's practices. So you could even say that this is rather a very active and prominent role that the Secretariat and the court plays throughout the duration of the proceedings.
Okay, thank you, Alexander. And going to some new trends, there is kind of a recent hype around technologies. For instance, we have seen institutions introducing new platforms to accommodate the needs of users, which actually proved to be valuable during COVID-19 lockdown period. How ICC IT thinking changed, and how do you keep up with recent trends?
Well, it's true that it might be seen as a new discussion. I am not fully certain that it is a new discussion. I think the use of tech is something in dispute resolution is something as old as the telex. You know, the ICC was a pioneer in this field in two respects. First of all, it had designed its own internal case management platform about 22 years ago. And it's now, of course, in the process of being revamped. And it also devised and launched an online case management platform, which was open to arbitrators, parties, and the Secretariat of the Court a number of years ago. As I said, we're now in the process of revamping both of these tools, and not in light of the pandemic. This is something that has started some time ago, and I hope will be nearing completion in the first months of 2021. This is, of course, necessary because all of us, as members of the dispute resolution community and the legal profession, must make that transition to a digital transformation. And institutions do have an important role to play in this regard, not only by enhancing their services in the way that I've described, but also in ensuring that all other stakeholders in a dispute resolution process understand and embrace the potential benefits that this digital transformation will bring about. And of course, as you both know, this goes into a number of things in daily interactions and communications, in the way hearings may be conducted, in the way document production may be conducted, and so on and so forth. All of those points have been taken into account in the revision of the ICC rules. New rules will be coming into effect on the 1st of January 2021. And there are a number of elements that in the new rules that highlight these points. Ultimately, I think, and since we spoke about the Baltics and perhaps also some disputes that might be of a lesser value and smaller complexity, our eyes are also set in providing online dispute resolution soon enough. That is going to be a completely separate service, I imagine, from the one that we currently provide under the ICC rules. And it will allow parties to settle, as I said, probably smaller scale disputes, but a more substantial number of disputes in a time and cost efficient way by using digital technology.
Mm-hmm. And going to another side of digital technology, have you noticed an increase of IT disputes over the recent years?
Well, one would need to define what recent years are, but I think if by that you mean in the very recent past, Kirill, I would say that yes, there was perhaps some hesitation within the IP sector, if we can call it that, although it's quite varied, as you know, with regard to the potential benefits of moving away from state court proceedings and into the realm of private justice, into the realm of arbitration. First of all, there is something to be said about the stakes involved in the dispute and the need to resort to very experienced court judges, and therefore there are courts in the world in certain jurisdictions that have that level of proficiency and ability to settle these cases, and also do that in a rapid way. I think what has happened in the recent years, again, is that there is more understanding that those same benefits that one might identify in a purely domestic context actually exist on the international context. And if you are indeed involved in cross-border transactions and in world trade, it will probably be much difficult to convince your counterparty to opt for domestic court proceedings. and more easy, of course, to resort to arbitration. So I think there is a progressive change. We have seen an increase in IP disputes. I must say, primarily in jurisdictions that export IP, and I would say primarily that is centered in North America, parts of Europe, including CIS to a certain extent, and of course parts in Asia. And I do expect that we will see more of that as the time progresses.
As for the last question, what would you say about enforceability of the awards issued by the ICC? Do you monitor this somehow, or do you receive feedback in an other way? What would be your comment?
Well, thank you. My comment would be the following. Obviously, the arbitral award, is the most important product end product of the process, and that is the document that allows you to connect, to compel collection or to connect. And you are, I am sure, familiar with the fact that the ICC Court has a very specific service that is basically an exercise in the validity and enforceability of arbitral awards, and that is called scrutiny. And therefore, under the ICC rules, the court reviews draft awards with regards to their formal aspects, and to a specific degree with regard also to the substantive aspects of the award as well, of the draft award as well. And no award may be released by arbitrators until such time as it has been approved as to its form by the ICC Court. Why is this important? I think it's important exactly, Maria, for the point that you've asked me to comment on. The purpose of scrutiny is to ensure that the award will be shielded from any potential validity risk or enforceability risk. And therefore, instead of waiting for a state court to conduct that review in setting aside or enforcement proceedings, we have integrated it into the arbitral process itself, so prior to the award being rendered. Do we monitor enforcement? It's difficult to monitor enforcement because at the time that enforcement may be sought, the case is already over. So we do rely on the information that will be relayed to us by the interested parties and counsel. We also, of course, monitor the media, and if we do become aware of and court practice. So if we do become aware of a publication of a judgment relating to an ICC award or otherwise any media report in this regard, we do take that into account. The data, therefore, is empirical. It's not fully statistical. What I can tell you, and I say this with a lot of confidence with regards to scrutiny and its benefits, is, for instance, out of the cases that we have identified in the course of 2020, the year is still not over, of course, only about 0.7% of all arbitral awards that had been rendered in the same period were successfully challenged in either setting aside or enforcement proceedings. I would hope that other institutions also share data, and this is an open invitation and one that I think we should all commit to, because it's important. It's an important way, I think, and a very eloquent way to demonstrate to our colleagues across the legal profession on the good benefits of institutional arbitration, and that this is a system that really works.
Alexander, thank you so much for your time and lifting the veil on ICC work. It was our great pleasure. And dear friends, we were here today with Secretary General of the International Court of Arbitration. Thank you for listening, and tune for the next episodes of Sorainen Arbitration Series. Bye.